All right, we are now streaming live on YouTube. This is the state of Georgia versus Naquavian Brown, charged in warrant number 2025 CW 50912, reckless driving, 2025 CW 50913, speeding, 2025 CW 50914, improper lane change, 2025 CW 50915, homicide by vehicle, 2025 CW 50916, homicide by vehicle, 2025 CW 50917, too fast for conditions. Representing the state is 88 Comic, representing the defendant is Attorney Mann. Go ahead, Attorney Mann.
Thank you. Please the court, Your Honor. Good morning.
Good morning.
My name is Frederick Mann. I'm a member of the Georgia Bar. I was admitted in, believe it or not, January of 1978, and admitted in Florida the following year. I'm AV rated for 26 years, and I'm a member of the firm of the law offices of Matthew C. Hines here in Atlanta, and I've been with this firm for over 7 years. My client is Nelquavian Brown. He is 19 years old. Just to recap, for the record, some of the matters that we covered this week, and I'll be brief, but this is about an accident that occurred on April the 10th in Clayton County, 50 days ago exactly, today. He was not arrested until April 21st. I believe that's 39 days ago. My client is an American citizen, born in the United States. He has no prior record. He graduated high school and was an A and B student in high school, planning on going to college and to study engineering. There were no eyewitnesses, according to Investigator Garcia, who we heard from day before yesterday, to the accident. This was a nighttime accident, a collision between two vehicles. Both the driver and the passenger in the other vehicle, which was an Acura Integra from 1991, are deceased. The passenger in the vehicle that was driven allegedly by my client, David Martinez, is available. We have a phone number for him, and he has not fled or left the jurisdiction of the court for any reason, and we plan on using him as a witness if we have to down the road. But the testimony from Investigator Garcia was that Mr. Martinez said that he didn't look out the windshield at the moment of impact. He had been looking at a cell phone, but that he was clear that the vehicle driven by the defendant, Mr. Brown, was struck by the other vehicle. That was his testimony. Now, Quavian Brown has been the caregiver for his grandfather, who is my first witness, and his grandfather is a double amputee and is in a wheelchair and requires constant care in his home all the time. His name is Larry Kirby. And in spite of all the pressures of school and working and so on and so forth, like I said, he was an outstanding student, A's and B's, cared for his grandfather, and after he graduated was actually working, I believe, 2 jobs. The speed of the other vehicle is unknowable. And that was from Investigator Garcia because he said it did not have the equipment, either the electronic data recorder on new cars or any kind of a module that was attached to any kind of an airbag. Okay, so that's something he's not been able to determine. He has completed, this was my understanding, or the agency has completed their analysis, forensic review of both vehicles, and both vehicles have been put in a tow lot. We would like to have access to those vehicles before any trial in this case, obviously, to have an accident reconstruction expert look at both vehicles.
And I'm going to object at this time. I believe we're going beyond the scope of this hearing. It's my understanding this is a bond modification hearing. What defense counsel is what he's asking for right now is something that will be more in line with a discovery request, which is not what being addressed in this particular hearing.
Okay, well, I'm sorry, counsel, that you're upset. I'll move on, okay? But I'm just trying to be as complete and thorough
I will say for the record that I am not upset. I am clarifying the record to make sure that we understand what we're doing today, which is a bond hearing only.
Okay, we're getting to that. Okay.
Yeah. Let's stick with what we're here for.
All right. The investigator did testify, just to complete the summary of the facts, that the speed at impact, according to the Georgia State Patrol officer, the trooper who did that analysis, would have been 78 miles per hour at the time of impact. The defendant was the one who called the police. So he is not charged with vehicular homicide for leaving the scene of an accident. He's charged with vehicular homicide for alleged reckless driving based on speed. He was at home for over a week before he was arrested. There was no flight. And Investigator Garcia was very forthcoming about the fact that the only video that was available from any source only showed headlights and taillights in the dark. That's all that could be seen. He limited his testimony Wednesday to say that the only thing that he could really say definitively was that he felt the defendant's vehicle was traveling over the speed limit at the time of any collision. There's been no analysis of the defendant's vehicle or the other vehicle, as I said, for issues such as brake failure, accelerator stickage, any kind of problem with the steering of the car. None of those issues have been addressed. The defendant, if admitted to reasonable bail, would be living with the grandfather and the grandfather's wife. Her name is Helen Kirby. They have resided here in the Clayton area, I believe, 3 years, both American citizens. The grandfather is very articulate. He would be my first witness. He's here today in a wheelchair. And without further ado, if I could call Mr. Larry Kirby, that would be my first witness for the bond hearing.
All right, go ahead.
All right, Mr. Kirby, come on over closer so you can be on the camera, and I'm going to move out of the camera if I can, or a little bit, so that the focus is on you.
Okay.
Would you like me to swear the witness, Judge?
Please.
All right. Would you raise your right hand? Do you solemnly swear or affirm that the testimony you shall give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. You can put your hand down. Would you tell the judge your name?
Larry Kirby.
And Mr. Kirby, what is your residential address, please?
2595 Lantern Lane, College Park, Georgia, 30349.
Okay.
And one more time. 29.
2595. 2595.
5.
Mm-hmm. Lantern Lane. Lantern, like LANTERN.
I mean, LAN.
TERN.
TURN. Okay.
And that's in College Park, Georgia.
Is that drive?
College Park, 30349. It's right on.
Lantern what?
Lane.
Lantern.
Lane, LANE. Yeah. Lantern Lane, that's it.
It's the word is lantern, Judge, like a outside lamp.
Yeah.
Right, but I'm saying, is it drive, street?
No, just Lantern Lane. Lane.
Lane.
Yeah.
Lane. Yes, that's what I was looking for. Okay, College Park. All righty. All right, go ahead.
All right. Mr. Kirby, do you know the defendant, Nelquavian Brown?
Yes.
And what is your relationship to Nelquavian, if any?
I'm his grandfather. Well, I'm his grandfather, but not blood ways. I've had him since birth. Me and his mother raised him because our daughter, my stepdaughter and her daughter, had him early age. So we've had him since all his life. And he's been with us forever.
Okay.
Yeah.
And you heard me tell the judge that you are disabled. Describe your disability, please, for Judge Cates.
I am considered uncontrollable diabetic. And I got a whole bunch of other health problems. I don't know the titles to them, but my blood sugar stays up and my blood pressure stays up and all that stuff. I'm in the best way I usually be today at court today. Attentive and talking and everything. This is the best I usually am. Usually I'm laid out sleeping on some medication or doing some other thing like that. I don't never leave the house anyway unless I'm going to the doctor or anything like that.
Okay. And you're sitting next to me, but the court can't see it, but you're in a wheelchair and you are a double amputee. Is that correct?
Yes, sir.
Okay. Is that as a result of the diabetes?
Yes, sir.
Okay. Now, since basically for the last 3 years that you've been in that residence in College Park, has Nelquavian been your caregiver?
Yes,
Okay, would he be the one to wheel you around the house?
he do all that. Yeah, he got a lot of duties.
Okay, he would take care of you, including personal hygiene and things like that?
Exactly.
Okay. And go to school full time at the same time?
He went to school, came home, did my stuff for me and everything else, and went to his job at Walmart at night until he got another job. And actually, when I say that, I don't want the court to think that he's just Superman. My job lets him work certain hours at certain different times, so he ain't constantly always working. He can work for me 2 hours and stop and come back and work another 3 hours or something like that. So he works around his school, he works around his job, because I'm basically just laying there anyway. I just want y'all to understand that.
Okay. All right. Now, are you familiar with the young man whose name is Braylon Greer?
Yes, sir.
Okay. Who is Braylon Greer?
Brandon is his best friend.
Okay. And is he someone that Nelquavian would spend the night with at his home on occasion?
Yes, he's the only place I used to let him go.
All right. And is Braylon Greer an outstanding student in his own right?
Yes, he is.
Is he a state track champion at this point for the state of Georgia?
Yeah, he just qualified for that. Was it last month?
Yes.
Yeah,
Yes.
he just qualified.
And he got a full ride to Alabama A&M. Is that right?
Yes.
All right. And his mother, Braylon's mother, when Nelquavian would spend the night over there, did she get to know Nelquavian?
Yes. Yeah.
Okay. Is she here today in support of Nelquavian?
Yes.
All right. And let me ask you this. If the judge were to admit Nelquavian to a corporate bond, in other words, a bond that requires the involvement of an insurance company, bonding agent and so forth, are you willing to be the guarantor on the bond? Are you willing to be the person to sign it along with Nelquavian?
Yes. I can guarantee everything as far as his bond goes. He's not a risk. He's not going anywhere. He's got a job. He's got a permanent address. Our family has been tight and knit all our life, and you don't have to worry about him showing up for court or trying to escape or anything like that. He is totally going to comply with whatever bond you set and whatever rules you give. And I'll stand for that with my life.
All right. And Mr. Kirby, did at the outset when Nelquavian was first taken into custody and put in the county jail, were you a little bit concerned about his personal safety?
Very much.
Okay.
Very much.
And just briefly tell the judge why you were concerned about his personal safety over at the jail.
Okay. Yes, ma'am. His first time ever encountering anything like this. And before he even went, the situation he was dealing with it hard himself, because he also knows that lives were lost in that accident. And that bothered him to the point where I thought I might have to get him counseling. And he was afraid of what may happen to him in the jail, especially since he was confronted the first night. I actually spoke to the chief of the jail there all that night on the phone. And I think because of me and her talking, she had her officers go back in that night. And that night they were going to jump him. I know this because he called me, but she did have him moved to a better part in the jail. So I am very grateful for her for listening and paying attention to what I was saying. But he's not used to anything like a jail. And I haven't been able to teach him anything about how those things are. So far as his bail goes, we know the situation and what's going on with what carries, and we know he's going to have to face court, and he may have to end up there, but we praying that he don't. But he's no kind of flight risk, and we want him out because he's not used to that, and he got thrown into that all of a sudden. And like I say, I want to get him prepared for that, and he can come back and help me and help us, because not only was he our caregiver, our grandson was also giving us that income to live here. He kept his own income from his other job.
Okay, so let me interrupt you. So he did receive a government check that was in recognition of the fact that he was acting as your caregiver when he lived in the house.
Okay, when you say government check, he's paid through the government. He works for through REMA for the government, because I'm on a program because of my health that the government authorizes me to have a family member. You seen those commercials that can work for me. So I can, that's the reason he worked for me like that. If it's a state check or through the government, I don't know. I got a caseworker who manages all that, and they hire him through that.
All right, but that additional income to help the family will be gone if he stays in jail.
It's gone already, so
okay. All right.
Yeah, he needs to be out so he can do that.
All right. Last question. If the court felt that it needed additional assurance other than the persons who are going to be resident in the house watching over him at all times that he's home, such as an ankle bracelet, an electronic monitor, are you willing to pay for that, to have that?
Yes, ma'am. Anything that y'all want to do to get him probation. He's not going nowhere, but he'll wear the ankle bracelet because he don't go anywhere. He just goes to work and back home.
Okay. Judge, I kind of lost you on the screen. Are you still with us?
Yes, I'm plugging up my device. It was going out.
Okay, I just wanted to make sure that you were still with us. That's all.
Okay, yeah.
Thank you, Your Honor. All right. Those are all the questions I have for the grandfather, Mr. Kirby. Your witness, counsel.
Good morning, sir. How are you?
All right. How are you?
I'm well. I'm 88 Andrea Thomas. I'm the prosecutor in this particular proceeding, and I'm going to have a few questions. I think pretty much only two. First question I have for you. You indicated your son, he has a job, he's in school, and he cares for you, correct?
Yes, ma'am.
Sorry, you said
no. He's out of school. He's graduated already.
Okay, that's great. I just want to get clarification. Now, do you recall what job he was working that night?
Yes, he was at C.W. Matthews that night.
What is C.W. Matthews?
That's like they build they do the asbestos stuff for the city to build the roads and stuff with. They break up all the concrete and stuff and make it's all different kind of stuff. But he works that part, and they come in the trucks and get it and take it to the highway department.
So he was working that job that night?
Yes. Mm-hmm.
And so does he actually lay concrete, or does he prepare the material that's used?
Yes, he puts the material that's used together.
So this is like a warehouse or something?
It's like outside though, they do a whole bunch of big heavy equipment stuff, and they got the big bricks they break up and stuff and all that kind of stuff. I can't tell you exactly, but it's like a concrete plant, but they're not really like inside or nothing. They in and outside. So
on occasion he would take breaks from that?
What do you mean breaks? Lunch breaks?
Yes, that's breaks? What I mean.
Oh yeah, I think so. I think I don't know exactly, but I think the job did that. I would think so.
But that's pretty. It's not like he's sitting at a desk or nothing. That's significant physical work.
Oh yeah, all day long. He gets inside tubs and tanks and have to break up stuff and all that kind of stuff.
Now you said all day long. Was he not at work that night? That's when this happened, right?
Oh, he was at work.
Yeah, this job, the concrete contractor.
Yeah. Okay. He was leaving work.
Okay. And the other young man, I believe you said his name is Braylon.
He wasn't in the car.
He wasn't? This is not the person that was in the car with him?
No. The person that was in the car with him, name was David Martinez.
Okay.
He was also a worker there.
Okay, counsel, just for the record, I think one of your questions asked him about his son, and he, I think, was making it clear that he considers him as if he were a grandson.
No, I didn't ask him anything about his son. I was actually just asking about the my last question was regarding the person in the car with him.
Right. I was referring to the earlier question, though. You did use the word son.
I don't think so. I was asking about a job, but in any case, let me ask my last question. So were you with him that night when the accident occurred?
Me?
Yes.
No, ma'am. I was at home. He called me that night when the accident occurred, though, because he was shook up and in shock and everything. After he called the police and stuff, he called me. You can have my phone to verify all that.
Oh, no, I don't need to know that. I just want to know, were you physically with him when this accident occurred? You were not.
No, ma'am, absolutely not.
So you yourself don't know from your own knowledge what happened that night, do you?
For me, knowing,
Yes.
I know what he told me and what the officer
Okay.
told me and everything else. That's all I know.
But that's not my question. My question is, you weren't there, so you did not see for yourself what happened, correct?
No, ma'am. No, I
Okay.
wasn't there. Let me see.
Okay, gotcha.
Mm-mm.
That's all.
Okay.
Okay, thank you. I have no redirect, Your Honor.
All right, any further witnesses?
Yes, I would like to call the lady that I referred to, Stephanie Barros. Ms. Barros is here
What
in
is
the.
she gonna offer, Attorney Mann?
She is a lady who actually works and counsels young people, young men in their teens, and is the mother of the defendant's best friend and has seen him personally on over 50 occasions over the last 3 years when he has gone and spent the night at the home. And she can vouch for his character, his responsibility, and being a polite young gentleman, basically, at all times.
All right, go ahead and swear her in.
Okay, Ms. Barros, come on over here, please, and let's get you a rolling chair to come sit next to the camera, okay?
Okay.
All right. Okay. Have a seat.
Okay.
All right, ma'am, would you raise your right hand, and I'm going to swear you in. Do you solemnly swear or affirm the testimony you shall give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right, put your hand down and tell us your name, please.
My name is Stephanie Janice Barrows,
Ms. Barros, what is your address for the record?
4030 Walani Road, Ellenwood, Georgia, 30294.
All right, and do you have a son?
Yes, my son, he's 18 years old, Braylon DeJour Greer. He goes to MLK, Martin Luther King High School, just graduated last week.
All right, and was he a friend or a coworker or both with the defendant, Noquavian Brown?
I would say both. When they got older, that's my son's best friend.
Okay.
Yes.
And during the last 3 years, did Noquavian come over to your home when you were there on multiple occasions and even spend the night?
Yes, he does.
All right.
And also too with the therapeutic children that I work with, they're boys, teenage boys. Naquavion, he would mentor them along with my son. They play basketball, football, ride bikes in the front yard. Have a large.
Sorry, what is that company called? Therapeutic?
Okay, the company I work for is Elks Aidmore, INC. We work with DFACs. Our children come from DFACs in several counties, several different surrounding counties.
Okay. And how long have you been doing that kind of counseling work?
I have been doing that for 6.5 years.
Okay. And how much education have you had?
Associate degree, 2 years in college.
Okay. And do you feel that Noquavian will come to court at all times as required if he's admitted to a bail that the family can post?
Yes, he would.
Okay.
Without a doubt.
And do you feel that he's generally a very reliable young man?
Very, very reliable.
Okay. If he, for any reason, needed transportation, because obviously he's without a car and without means right now to go back and forth, would you assist the court?
I sure would.
In bringing him to the courthouse?
I sure would.
Okay.
Yes.
All right. Your Honor, those are all the questions I have for Ms. Barrows.
All right, ADA Thomas.
Good morning, ma'am.
Good morning.
Just one question. Were you with Mr. Brown the night this incident occurred?
No, I was not.
That's all I got, Your Honor. Thank you.
All right, any further witnesses, Mr. Mann?
Your Honor, I had some, but I think that in a spirit of trying to help the court this morning, the other witnesses would be his mother, his grandmother. I think you can anticipate that they would support him and say that he's a good boy or a good young man, that he's not somebody who's going to be a problem. So I'm going to waive calling them. We also had, his aunt is somebody else that I wanted you to hear from. Do you want to see if she can step in for just a minute, the aunt? And that'll be the last witness. And just for the record, while she's getting the aunt, Judge, there was an uncle who is a retired United States Navy commander who lives in Virginia, and unfortunately, on short notice, he was not able to come down here. But he was retired after over 20 years of service, and he would have also supported the application for bail.
Okay.
All right, ma'am, come on over here and slide that chair on over so we can get you on the camera. Okay, and I want you to raise your right hand. Do you solemnly swear or affirm the testimony you shall give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you're going to have to speak up nice and loud, okay? You can put your hand down. Tell us your name and your address, please.
Autumn Flowers, 2595 Lantern Lane, College Park, Georgia, 30349.
All right, so you live in the same house with Mr. and Mrs. Kirby, the grandfather and grandmother of Nilquavian, is that right?
Yes, sir.
How many years have you lived there?
2 years.
Okay. And are you working or going to school right now?
Yes.
Phone is that ringing?
I'm trying.
The grandfather's got multiple cell
Okay.
phones here. We're gonna.
Okay, it's off.
Okay,
All
I'm
right.
ready to get that claw hammer and start swinging. But, okay, all right.
All right.
All right, I'm sorry. Let's go back to the question. Okay, how many years have you lived in the Kirby household with Nilquavian Brown and the grandfather and the grandmother?
2 years.
Okay. Has he always acted in a responsible manner, and have you seen him specifically act as a caregiver to Mr. Kirby?
Yes, sir.
All right. Would he be constantly taking care of Mr. Kirby when he was not working or going to school?
Yes, sir.
All right. And you never saw him engage in any kind of emotional outbursts or fights or arguments or anything with his grandfather? Is that a fair statement?
No, never.
Okay. Do you feel confident that he will attend court at all times as required if he's admitted to bail?
Yes, sir.
And do you drive?
Yes, sir.
And do you have a driver's license here in Georgia?
Yes, sir.
Would you assist him if he needed transportation and come into court at any time as to appear as required?
Yes, sir.
Okay. And you've never been convicted of a crime, right?
No, sir.
Okay. You're an American citizen, right?
Yes.
Where were you born?
Haytown, Missouri.
All right. That's all I have from me, Aunt Judge.
88 Thomas.
Good morning, ma'am.
Good morning.
Were you with your nephew when this incident occurred?
No, ma'am.
Okay, that's the only question I have. Thank you.
Okay. No further questions, Your Honor, from counsel here for the aunt. Thank you very much. You're excused. All right.
All righty. So 88 Thomas, you're up.
Your Honor, from all accounts on the defense side, it appears this is a good young man. And by good, I mean he appears to have been trying to do what he's supposed to do in life. It doesn't appear that he has any criminal history. However, I've got 2 victims, a husband and a wife who are deceased, who appear to be good people too. They were good people who had family. They're good people who had 2 minor children who are currently living with their grandmother. The grandmother, after all this time, still has not told them that that their parents are deceased. She doesn't know how. So these kids are still asking, when is mommy and daddy coming home, not knowing they're never coming home. Your Honor, the pictures of this incident are absolutely horrific. These kids have no idea that this is what happened to their parents when they went out that night. Could have been a date night. I don't know. All I know is that based on the officer's testimony, neither one of these folks, the victims, did anything wrong other than drive on the streets of this county, which citizens of this county are entitled to do. The officer indicated in his testimony there was no evidence whatsoever that they left their lane of travel or that they were traveling at an excessive speed. He did base this on an analysis of what's called the yaw marks on the street. That's part of a training, which incidentally, I've had that same training. You learn how to go out to a road and read the road, literally. You look at the markings, you look at the residual evidence, if there's any broken car parts, what have you, and you make a determination of what possibly happened. The most likely event that happened. On this particular night, based on what the officers advised the court, these folks did nothing other than drive. On the other side of the street, however, they had the misfortune to come into contact with Nelquavian Brown. Now, based on what we're hearing from his grandfather, this young man has a pretty busy life. He's in school. He's working possibly multiple jobs. He was working a job that particular night that appears to be very physically demanding. Then he comes home and he assists with his grandfather, which includes his personal care, which is also physically demanding. I don't know if he was tired. I don't know if he wasn't paying attention. I don't know if he was blasting his music. What I do know is that based on that officer's testimony, when they analyzed the airbag sensor, within the 5 seconds immediately preceding the deployment of that bag, this young man was traveling in excess of 100 miles an hour. And when the bag actually deployed, I believe it was 78 miles per hour, at which time he had left his lane of travel and came into contact with the victims. It's my understanding that they likely died instantly. Based on the severity of their injuries, I truly hope they did. Nelquavian Brown was recklessly driving that night. I hope he was looking out for his own life and the life of his passenger, but it appears he surely wasn't looking out for the lives of the victims in this case. That reckless driving is what makes this a felony. And because he is apparently unable to make an adult, rational decision on how to operate a vehicle, 2 people lost their lives. And 2 kids no longer have their parents. You see, because victims have families too. And I'm glad to see that Mr. Brown's family thought enough for him to appear and testify to you. That his best friend's mom came and it gave her impression of this young man's character. But nobody's explained how anybody's going to explain to these kids how their parents didn't come home that night and will never come home again. You know, I hope that the court will keep all of that in mind when it's looking at the bond factors here. I don't believe that he's at risk of fleeing the jurisdiction. I don't believe he's at risk of intimidating the witnesses because the 2 witnesses that we have are no longer with us. What I am concerned about, however, is that he could be a threat or danger to any person in the community, because if he's out there driving and he's been working one of these many jobs or he's been caring for someone, he could put somebody else's life in danger. He used extremely bad judgment that night. I would hope he wouldn't commit a felony, but if something like this occurs again, we've got another felony. Possibly someone else is deceased. So, Your Honor, state would ask the court to set no bond in this matter, and if the court is so inclined to set a bond, that bond be commensurate with the severity of this matter that is before the court. That's all I have.
All right, go ahead, Attorney Mann.
Thank you, Judge. Just a couple of points here. The speed of the other vehicle at the time of the actual impact is unknowable, according to Investigator Garcia, again, because there's no device that was reading speed that was recoverable. It's not even known whether or not, from his testimony, they had seatbelts on at the time of the collision. So I don't know if that was a factor in what happened. If the court ruled that a bond was appropriate for Nelquavian, and he is not allowed to operate a motor vehicle while he's out on bond, that's fine. We will abide by that, and he has family support that will assist him and give him transport if he needs it to get to a job. That will be a baseline in this case. And I've met him. I've spent a substantial amount of time talking to him, over an hour at the jail, and I think that he will be a model defendant on bail if the court were to admit him to a corporate surety bond. After listening to the case before us about the young man that was charged with sexually molesting a young child, and receiving a $20,000 bond. I think a bail in this case that would be appropriate would be something in the range of $25,000 to $30,000 corporate suretyship, which would require, of course, an insurance company agent be involved. They will also be monitoring their investment in the case. And these are American citizens. These are not undocumented immigrants. A corporate bond company or an insurance company that writes corporate bail bonds, I have no doubt they'll be standing in line. They've already been soliciting the family, probably about 3 or 4 of them, to write a bond for nil quavian. So I'd ask the court in its discretion and experience to recognize the tremendous support structure that exists here and to give him that chance. Thank you.
All right. And so, ADA Thomas, I know your position is no bond. If I were to set a bond, what would the court, what would you prefer as the bond? What would you recommend?
Your Honor, I'm stuck at no bond because in my mind, this is a homicide. This is a murder. So I just honestly don't have, I don't have a recommendation on this one, Your Honor. I do know it would involve no driving, but as far as a dollar amount, I just don't have one.
Right. And so, ADA Thomas, I agree with you. This is tragic. It appears that a nice, law-abiding young man that was working, graduated from high school, just helping his grandfather, made a horrific mistake. He caused an accident that took 2 people's lives. I can't imagine life right now. I can tell by watching Mr. Brown that he is devastated by it. But unfortunately, when you drive, and I know that we don't know exactly, but based on the officer's testimony, when you drive at that speed, there's no way you can control a vehicle in a 40-mile-per-hour area. Like it was a terrible mistake that has cost a lot. My heart goes out to those children that now don't have a mother or a father. This is a delicate balance because although I feel passionate that he's young, he did something really, really stupid. A lot of what I try to talk to our other youth about, and about speeding and how dangerous this could be. But I also have to consider the victims, the victim family. And it's a really hard balance. So I am going to set a bond as follow. And so, Mr. Mann, yes, you will have to go ahead and take this down. All right. I'm going to keep the reckless driving at 2. The speeding is already set. The speeding is that 2,500? The speeding was at?
Hey, I'm sorry, Judge, I don't remember.
No, I was asking ADA Thomas.
Your Honor, give me 1 second. I need to pull up that other calendar, my old calendar.
I believe it was set at 2,500.
Speeding is 2,500.
I'm going to keep that at 2,500. Speeding, okay, that was 2,500. The improper lane change, that's going to remain at 500. And then too fast for conditions is going to remain at 500. For the first homicide, I'm going to set that at 25,000. Second homicide, 25,000. So what did that come up to?
It looks to me, Judge, like it's 55,500.
That's wait, hold on. I am going to actually the speeding because of the egregiousness of it. I'm gonna put the speeding at 5,000. The reckless driving will be 3,000. So the reckless driving will be 3,000. The speeding will be 5,000. Improper lane change will be 500, and the two homicides will be 25 each. He may not operate a vehicle at any time. He may only leave the home for the purpose of work. I'm going to put church in this one. Court. So in essence, you're on house arrest. Court or any doctor or hospital visits.
Thank you, Judge.
Hold
And
on,
you
I'm not,
said-
hold
you
on,
said-
I'm done. I'm not done yet.
Okay.
So when you get out, Mr. Brown, your life is not the same anymore. All right. Your history and people, especially people at your age, don't understand this, but your history plays a huge part when you come, if you come before a court, your history plays a huge part in how the court handles your cases. So, 88 Thomas, is there any counseling or anything that you would suggest on this one?
He needs to take risk reduction, Your Honor, if I'm not mistaken. I think defensive driving, wait a minute, risk reduction is for DUI
Right, okay.
and defensive driving is just general driving.
Okay.
There doesn't appear any evidence that alcohol or any other substance was involved, so defensive driving would probably be good. The only question I would have about that is whether or not that would involve him operating a vehicle. I'm not sure if it's strictly coursework or if it's coursework and
Coursework.
okay, then
No,
that,
it's no driving, it's coursework. I do know that.
I think you can take it online, Judge.
Yes, you can.
Okay.
So make sure we're doing that online. All righty. Any other conditions, ADA Thomas?
I'm just want to make sure I've got this correctly. I have down work, court, doctor, order to be prepared by a defense attorney. He's also to do defensive driving.
Within 60 days of being released, completed.
No violations of the law and no weapons is the only other thing I can think of, Your Honor, but that's kind of standard.
Right, and so definitely no violations of the law, of course.
I think that's it, Judge. I had a question though. The too fast for conditions had a bail of 500. Is that right?
Yeah, yes. So
Okay.
what's the total amount we come up with now?
It looks to me like it's now 59,000.
Also, he is to remain and reside at that house. If you can put that address in there. He is
25
not, I'm
20
sorry,
2595
Lantern Lane.
Lantern Lane,
right.
College Park, Georgia,
College Park, and the zip
30349.
30349.
Right,
Okay.
okay, and so he is not to spend the night anywhere else, he is to be there, unless he is working, church, and all of that good stuff. He
Okay.
is not to go anywhere, and preferably, working during the day, so at night, he would be at home and in his home, him being at home can be verified.
Yes.
Yes, ma'am.
All righty, anything further? Okay, go ahead, 88 Thomas, I'm sorry.
Just a quick question. It might have been that I missed it. On warrant 2025 CW 50917, that's too fast for conditions. Did the court set a bond on that one? Did I miss it?
It was already set at 500.
Okay.
I just left it there.
Yes,
Yeah,
ma'am.
ask me a
And
question.
then the speeding went up to 5,000 and the reckless driving went up to 3,000.
Your Honor, Mr. Kirby wanted to ask you one more question, if you would.
All righty, go ahead.
Yes, ma'am. Attorney, the district attorney told about the family. My grandson didn't know that. We were aware of the family and the grandchildren and everything, but I was just saying, if we need to take him to counseling for this, are we allowed to take him there? Because I had
Yes.
already called a grief counselor, and she said that they're on the street right above us. So I just want to have permission to take him there if he needed. I don't know
Yes,
if he.
we can add counseling to the list.
Okay.
And I'm sure he will need some help.
Thank you.
Thank you, Judge.
All right. And I did put church on there because if you don't have one, you may need to start going to one.
As soon as he get out of there.
All righty. All righty. Well, sir, again, my heart goes out to you. I hope that this day forward you can find a way to get through this. All right. Good luck to you, sir.
Thank you.
Thank you very much, Judge Cates, and that concludes my business. May I be excused?
Yes, I think that concludes all of our business.
Okay.
Thank you, Judge.
Have a good weekend, Judge. Thank you.
Have a good one.
Okay.
Thank you, 88 Thomas. You have a good one.
You too.